Thanks for staying with us here on the Urban Debate at 9 p.m. This is a special broadcast where we are breaking down the new set of guidelines for digital media that the government has brought about. Guidelines for social media, for OTT platforms, as well as for news websites. But let's begin with what is in it for you as a user, as a consumer. Well, you can now file a complaint with the platform's grievance cell. The platforms have been told they must have a grievance cell with officers based here in India. These grievances will then have to be resolved in a time-bound manner. So there are specific deadlines that have been set up. It cannot be that you raise a complaint and you raise an issue and then you don't hear from the social media platform for several days. So the grievances will have to be resolved in a time-bound manner. When it comes to posts against a woman's modesty, posts which are threatening, posts which are linked to rape threats or nudity or any other sexually explicit material, those will have to be removed in 24 hours after a complaint is made. You, even if any user gets blocked or some of their content is removed, you will have an option of explaining yourself. They will have to give you a chance before any action is taken. Outside of that, the main part, like I said, is the grievance redressal. How is it going to work? Well, the government has structured it in a 3-level format. Level 1 is going to be largely self-regulation, which will mean that you will have to have a grievance officer who ensures that the complaints are addressed and a resolution is actually given within 15 days. So this is where the your intermediary on digital platforms will have to ensure this is done. Level 2 is then creation of self-regulating bodies. These bodies can have 4 to 5 people. They will be headed either by an eminent person or they can be headed by a retired Supreme Court or a High Court judge or an independent eminent person. They can't have any more than 6 members. They will have to register themselves with the center saying, well, we are a self-regulatory body for this segment, and they will have to follow a code of ethics. And above that, at level 3, will be the oversight mechanism. This oversight mechanism will be formulated by the government, by the Information and Broadcast Ministry. It will essentially be kind of a charter for the self-regulating bodies, and they will have to then create a interdepartmental panel that looks into grievances that get escalated to this point. Now, let's try and understand. Considering that we had a legal setup already in place, some of these social media platforms have their own policies as well. How does it all now boil down to what's been announced today? What changes? And are there any concerns, legally speaking, as a citizen? So let's say good evening to Dr. PAVAN DUGGAL, cyber law expert joining us this evening. NAPPINAI, advocate with the Supreme Court and also a cyber law expert, joins us this evening. Prashant Sugatan, technology lawyer and legal director for SFLC. And Mr. Sidharth Luthra, senior advocate with the Supreme Court. Good evening to all of you. Thank you for joining us. Let me start off with Mr. Luthra. Mr. Luthra, for a really long time now, we've had debates and controversies regarding the accountability and the transparency of the social media giants. So let's begin with that part. Is this a good step forward in making them accountable?
Let me put it to you in 2 levels. The first is, so far as OTT is concerned, OTT was self-regulation and there was no norm on it. Today, there is an attempt to ensure that OTT is regulated, and that's a matter which have to be tested as to what is the extent of regulation the government is trying to do, although they call it self-regulation, but there's a matter of concern here. The second is regulation of social media. Now, the problem that I have is this looks simple, though if you look at the regulations, and I've got the 2021 regulations before me, the issue that really arises is under the guise of controlling information which is offensive to people, which is offensive to the law, is this not going to be a situation where you are breaching Article 19? Now, that's a matter of concern which needs to be seen. And the other aspect is I'm not very satisfied with the extent of consultation that took place, because my understanding is, and even if you see what the government says, the consultation is supposed to be done with, they say they got 171 comments from individual civil societies. So is it a case where you brought in regulations hastily? This is not the first time that this has been sought to be done. And my concern is that this will be a clampdown on information, and that is a matter which needs serious merit and consideration.
Okay, interesting that you lay it out like that. And in fact, let's take it forward from there and ask Ms. NAPPINAI, what is your view? And, especially with what Sidharth Luthra is saying as the key aspects to watch out for.
The most important aspect I would want to highlight as an opening statement would be the inclusion of digital media in an intermediary guidelines rules. Because where it is an intermediary which is disseminating content, it could be video, audio, or it could be news, then automatically they are regulated under intermediary guidelines. But what the part 3 of the proposed rules point to is regulation of online content hosting platforms, OTT, and also of news media. Now, you can't bring that in either under the IT Act or more specifically under Section 79, which is specifically for intermediaries. So you can't expand it to include intermediaries and others. And 69A, these are the two provisions that are predominantly being relied on. 87 is just the rule-making process for these two substantive provisions. 69A also is very specific to say that blocking order can be issued by any ministry at joint secretary level, but it can be issued only to an intermediary or government agency. A news media or a content hosting platform which is curating the content or which is developing the content as a publisher is by its very nature therefore not an intermediary. An intermediary can only transmit something and have no control over the content or the person from whom and to whom it's going. And therefore, to force fit something like digital media into an intermediary regulation is serious overreach and is bound to be shot down.
Well, in fact, interesting that you make that point, because just in our last segment, we also had the News Minute founder, Danya Rajendran, here with us, and we were talking about the same issue and about possibility of illegal recourse. Prashant Sugatan, legally speaking, is this a problematic point? The fact that the news websites, the digital news websites, have now been brought into this category.
Definitely, the classification where the government is looking for a level playing field, that is definitely problematic. The kind of classification that you are going to bring out to bring digital media under these guidelines. In fact, when you had the earlier guidelines, that was only restricted to intermediaries. Now you have brought digital media platforms also under these set of guidelines. So, although the government talks about a level platform, the question is, what is it that you're trying to regulate, and how much you can regulate? The kind of three-tier mechanism that is being proposed, that also sounds problematic. Where, although it is called self-regulatory, there is a lot of government control. So it is quite different from a usual self-regulatory mechanism where the stakeholders will have a say as to how it is to be done. But
you say this because of the level 3 where the government panel comes into play. Why are you saying that this will be a little bit more tricky than the usual mechanisms that we see?
It's not at level 3, even at level 2.
Okay.
Where you have, if you look at if you look at the members who are part of it.
Yes.
So it is not like a usual self-regulatory mechanism where it is done by an industry body, where there is no outside interference from the government or other bodies as such, other regulatory bodies.
Okay.
So this is quite different from that kind of a model.
Fair enough. Interesting point. Now, the argument that I heard in our last segment, Mr. PAVAN DUGGAL, was that, well, it's not just about these handful of established news websites which are there. There are so many, mushrooming as portals, in the garb of news, even on YouTube. Anybody can now start a channel and talk about disseminating news. And how do you then keep a control? How do you then track? Where is the tracking mechanism or a control mechanism in that sense? Do you buy that argument, or should the two have been separated?
I think we need to quickly understand that while we are working towards a ubiquitous internet, you will still have distinctive verticals. While there'll be some overlaps, but they will have to be distinctive buckets in their own self. So the moment you're trying to put everything under the sun, under one umbrella, you're bound to have practical problems because apples and oranges cannot be compared with each other. Having said that, when you look at the IT Act, the mother legislation, it never was a legislation that was meant to either control content or news or generation of content. It was only limited with certain limited aspects pertaining to certain kinds of content. But now, under the garb of this mother legislation, you are coming up with rules and regulations which the mother legislation never ever envisaged. So, effectively, it's a classical case of a secondary legislation going far beyond the scope and ambit of the primary legislation. And that itself is a grey point where a potential legal challenge to the said rules could be coming forward in the coming times. But even otherwise, the question is, internet has already transformed all of us into becoming global authors, global transmitters, and global broadcasters of data. So we are all news makers, we are all news creators, and we are all news disseminators. In a scenario like this, the bigger question will be, in which category are we going to fall? Are we news? Are we intermediary? Are we just a data repository? Are we a social media intermediary? Are you a significant social media intermediary? So effectively, we have this immense kind of practical problems. There's far more chaos, vagueness, and confusion in the way the said rules have been prepared. They are in complete contravention with the provisions of the mother legislation. Specifically, when I read the provisions of section 87.1, 87.2, and 79 of the IT Act. And also the focus of this entire rules and regulations are only particularly focused on a particular category of intermediaries, being number one, either social media service providers or OTT platforms or news creators. What about the humongous volumes of other intermediaries who do not fall into any of the other three categories, but are nonetheless qualified to be covered as intermediaries under Section 21W of the Information Technology Act 2000? A local kirana wala shop guy who's just having a couple of computers or who's having connectivity also becomes a network service provider and is an intermediary. Now, if you're expecting all these intermediaries to do all these additional sets of compliances, what you're effectively doing is you are creating more increased, enhanced costs of compliance. You are going to increase the levels and heads of compliances. And more significantly, that's a short formula that whatever the compliance was to happen with these rules and regulations, they are not going to happen. And the chances are that over a period of time, these rules and regulations may just merely become paper tigers, because as of today, the effective enforcement of these rules are itself in big question.
Except in cases where there is a larger intent and a will to ensure that you do comply with the norms. But yes, and I'm glad you said this, because this was one of my own bigger apprehensions, that while it looks good, even from a user protection point of view, how much of it will on a regular basis get implemented, and where is the accountability? Where is the accountability to say, oh, the social media platform that today takes 5 days to tell me or 20 days to tell me, we've looked into it, we don't see any problem in the issue that you've raised, and thereby we are closing this case. Will they have to give me a clearer answer here on under this new regime? I don't know. We'll come to that aspect. But I want to address the first part of what you said also, Mr. Duggal. And Mr. Sidharth Luthra, since this is not a law, it's a set of guidelines and regulation that's been brought in. If it doesn't sink in with the existing IT law, won't that be a problem?
You're absolutely right. And I think Pavan's made a valid point. In India, the traditional method of legislation was that the parent legislation sets out the basic law, and if there's any fine tuning or any specifics that have to be brought in, that's brought in by delegated legislation, which are regulations. Now, there are two aspects to consider it, and this is the problem with technology law, because technology is far, far ahead of lawmaking. We know legislatures have their own processes and they take time. Therefore, the one thing that this law is teaching us is that we will perhaps eventually end up with a shift from legislations which are comprehensive with limited delegated power. And this seems to be a working of that. Having said that, for example, like the Epidemic Diseases Act has 3 provisions, the rest of it is all left to rules and regulations. And that is the kind of legislation we've had in the past, but for the last 70, 80 years, post the Constitution, it was very clear the delegate had limited power. This is, of course, susceptible to challenge on the ground that it exceeds the scope of the parent legislation, and 69A is the blocking provision. I'm really concerned why 69A is being used to trump Section 79, which was a clear protection to an intermediary. After all, what's an intermediary? An intermediary is somebody who provides a platform. By way of example, it's like the MCD providing a road. People have an accident. Are you going to hold the MCD liable?
Right.
So this is the kind of issue that you need to deal with. The other thing which I must add is, there is an aspect regarding the issue-related guidelines which I was seeing, and these are to be read with the 4 general guidelines. Now, there's a matter of some concern on category classification. Now, some of those relate to psychotropic substances, obscenity, etc. I can understand that. But the other issue is this an issue of overkill? Is it not that using the issue-related guidelines, you're really restricting the amount of public viewing that can happen? And we have to understand the internet is an open space. Social media is an open space. We can advise, but we can't come down like a hammer and destroy the very fabric of an open society. We've gone far beyond, and I'm surprised that it refers to the Press Council guidelines. The Press Council guidelines were for a totally different media, which is the print media. We have to see the here and now. Today, as Pavan said, everybody has the ability to speak their view. Of course, I must be careful not to be offensive to others, but that doesn't mean that if I say something and people take offense, I'm going to be prosecuted, and that's the big concern in this.
Okay, that's a very interesting point that you make, and actually it's very dangerous if that is what could happen. Prashant, do you want to weigh in on this?
Okay, so as far as the law is concerned, definitely this is going to be a part of the law. This is although it is it's termed as guidelines. These are, as Mr. Luthra said, these are subordinate legislation which are part of the IT law framework.
Right.
And yes, Section 69A is going to be problematic because this, the way it is, the way the orders are issued, these are often confidential in nature. There is no transparency as to how the whole procedure is, and that definitely is a problem. And when we saw what happened with Twitter for that matter. So when such orders are going to be issued by the center, and this is more so in the case of the traceability provision, when the government is going to come out with an order to ask the intermediary to find out who the originator of the content is. And this definitely is going to affect the rights of people, the privacy of citizens. And when you have specific clauses, like for example, let's say the original message is from outside India, and then you have somebody in India who forwards the message, you need the originator in India. And that means you need the entire chain. It's not just the first person. And this is the entire metadata as well as the message is concerned.
No, but the metadata doesn't have to be shared. The entire chain doesn't have to be shared with the government. Is it just the originator, just the first guy who created it?
The first guy. What happens if the first guy is based out of India? Based let's say in the US or in some other part of the world.
Right.
Then the person who is in India will be responsible, right? And again, it is not very easy for a platform like, for example, let's say Signal. I mean, a lot of people have moved from WhatsApp to Signal now.
Yes.
And you have there's a condition where you need 3 levels of officers: a compliance officer, a grievance officer, 3 levels of officers who are going to be Indian citizens based out of India, and an office in India. And Signal is a non-profit entity. And if you really want such organizations to comply with these regulations, it becomes problematic. They will maybe also choose to cease operations in India, deny their services to Indian citizens. Do we really want such kind of a scenario?
Well, Signal has actually in the past done that in another of the nations where they were asked to reveal a lot of information, and they said, this is not how we're going to do, and these are not rules that we can follow, and they packed up their business and left from there, which is why they're actually widely respected in terms of protecting the people's privacy. But of course, yeah, Mr. Luthra, you wanted to make a point before I go to others?
Yeah, I wanted to clarify that under Section 75 of the existing Act, the Parent Act, the Information Technology Act, this Act applies to offences or contribution committed outside India by persons irrespective of nationality, as long as the impact is in India, it relates to computer resource or computer network India. So the extraterritoriality exists in the statute as even today. So that's an issue which has to be dealt with in the process of an investigation. You have to have recourse to letters rogatory. It's not that you can't prosecute. I mean, today you have Nirav Modi who is abroad and he's being extradited. So it's not that it can't happen. The law can reach out to people outside jurisdiction, and this makes it possible. That's the point I wanted to clarify what Mr. Surathan has said.
Okay, we've also seen NS NAPPINAI that the government has repeatedly said that when we ask you under the current IT law, and this is the action you need to take it immediately, you need to implement it immediately. There was also, apart from the detailed regulations, there was also a comment that was made, the double standards, as in we saw with the reaction to Capitol Hill violence versus the Red Fort violence, will not be tolerated. Now, while I understand the messaging, is there a danger in the way the law is designed to say that if the government says crack down on these 5,000 accounts and groups and just shut it down, and that's that?
Yeah, so I just wanted to comment on a couple of things and probably a little bit of a contrarian view on certain aspects. And the first of it is this: we are going on a premise that I would put it the other way around. Are we going on a premise that OTT platforms or news media online does not or should not be regulated? Or are we going on a premise that they ought to be regulated, but this is not the way to regulate them? My point is actually with respect to the latter, because there are certain points which have been raised. The intent may be good. There are certain aspects in terms of creating level playing field that has been raised. All those are fair points. The point I feel, the focus I would want to put is on whether doing it in the manner it's being done now is correct or not. And that is what I'm saying is incorrect. But the issue of whether a level playing field ought to be created at all or not can definitely be evaluated. To merely say that the platform is now different, it works differently, does not necessarily mean that it has to be dehorse regulation. There are enough jurisdictions which have already laid down sufficient regulations for all these. To come to the point that you raised with respect to the fracas that has already arisen and that was also mentioned in the press conference today with respect to differing standards, even under the current law and the regulations framed as they stood, the government was within its right to seek certain remedies. Whether it should always be a remedy of blocking is actually the real issue here. There are other alternatives in terms of moderating, regulating, taking down, and as a last resort, blocking. So even if you look at the Shreya Singhal judgment and the way it deals with whether 69A is constitutionally valid or not, what comes out when you juxtapose what happened then to now is there was possibly not even an iota of thought that it could be used in the manner it is being done today. So the overreach aspect is what is concerning, but a very basis to say that there ought to be regulation for intermediaries, there ought to be accountability for intermediaries, there has to be a methodology which will help users for expedited takedown, especially where content that needs to be taken down is so precisely set out, and also in the appropriate forum, in the appropriate manner, regulating anything else, including OTT or otherwise, to say that we want to bring everything on par is a different issue. But to just say everything is bad, self-regulation is the best alternative and the best way forward, and therefore why can't we just let things be, may not necessarily cut ice.
Okay, Mr. Sidharth Luthra vehemently disagrees though.
The only issue is, how can you justify it under 69A, which talks about the interest of sovereignty, integrity of India, defense of India, security of the state? I really want to ask, and this is not the first time it's been done, how can you bring in regulation of content under friendly relations with foreign states. Now, this is, I must say, incitement to an offense. Is this what we're going to do? Are we going to use a blocking provision to bring in? If I say, if the government wants to do something, there is a legal mechanism. They can go to Parliament and re-examine the law. But to use this backdoor entry, which I must say, unfortunately, has been used in the past also, is something which is abhorrent to the rule of law. And that cannot be countenanced. And I'm really concerned about this as a citizen, as a professional. It's all very well to say there should be digital media, there should be an ethics code, but you bring in everything under the sun. I think this will need to be tested in the courts sooner than later.
With this intermediary guidelines, which is that, we have seen 69A and the way it was used and the way it has been upheld and Shreya Singhal. From 2015 to now, we have seen how it has been used otherwise, right? Here is an opportunity for this issue to be taken before court and for a review in terms of even what are the parameters and what is the limitation in terms of how 69A should be used or should not be used rather. Or whether it should survive itself in the books, in the law books at all or not, or as a legal provision, so to say. So I would say here is an opportunity, and I truly hope that this is also taken up along with this sustainability or otherwise, and clearly unsustainable aspect in terms of the digital media regulation that has been brought in, because that is what will then bring succor to the various contentious issues that we have seen over the last few years.
All right, just for our viewers' understanding as well, Section 69A of the Information Technology Act is essentially what gives the government the power to come in and ask the intermediaries to block certain content, to pull down certain content. And like Mr. Sidharth Luthra was saying, this can be done for reasons of sovereignty, integrity of India, or in the national interest. If there is something which is against the national interest, the government can then ask the intermediaries to remove this objectionable post or content immediately. And if they don't follow, then they can also be an extremely tough penalty, including jail terms. So that's as harsh as it can get, and it has been upheld, like our lawyers just pointed out. If I may just move to the second aspect and specifically talk about the OTT platforms. That's the other part, and because again repeatedly we have many conversations with Mr. PAVAN DUGGAL about censorship, what can be allowed, cannot be allowed, hurting religious sentiments, too much nudity, vulgarity, all kinds of ideologies, and those conversations, debates repeatedly come to the fore. Now, while one can appreciate the fact that they said certification is needed, you label your content, you bring in some kind of a parental control or a parental lock system, but is there also something in these regulations that talks about censorship or taking these OTTs to task for their content?
Well, let me begin by saying that there is some fundamental confusion. I'm confused. Is an OTT player not an intermediary? Is an OTT player not a social media intermediary? Or is an OTT player not a significant social media intermediary? So the problem is, you have now created a new category. Yes, it's a common parlance word, OTT, over-the-top application. But when I look at the mother legislation being the Information Technology Act 2000, OTT players would still qualify as network service providers and hence will become intermediaries under Section 21W of the IT Act. Yes, you would want to regulate them because a lot of content is coming up which may prejudicially impact the mindsets of people in India. Well taken point. As a sovereign government, you have the power to do so. Well taken. The question is, how are you going to enforce this particular rules and regulations? In the last 20 years, if we have not been able to practically enforce the extraterritorial jurisdiction provisions under Section 1 and Section 75 of the IT Act, I see very little chance that we will be able to practically implement this on legal entities of OTT players who are physically located outside the territorial boundaries of India. And more significantly, the particular rules are themselves lacking the effective parameters of their efficient and effective implementation. So I see a huge gap. I see, yes, there are going to be now those groups of OTT players who will say, look, I will comply to some portion. There'll be others who will say, look, I neither have the capacity nor the resources to go ahead and comply. And rather, I like to forget about the Indian market. I am going to be in my jurisdiction. Whether my services are available in your jurisdiction or not is none of my concern, because internet is ubiquitous. And even if they are, there's nothing that I will do in terms of compliance. So I think there are more seeds for these rules to be not complied with, or to be more seen in breach rather than in compliance in the coming times. And because there is a lot of discretion elements and the elbow room that's been given to the government, I think there are going to be intrinsic conflict in the said discretions which are given under the rule vis-a-vis the ultimate discretions which are given under the mother legislations. For example, can the effectiveness of Section 69A, being the power of blocking under the IT Act, be diluted or be morphed into a new manifestation or a new avatar under the garb of rules under sections 87 and 79 of the Information Technology Act 2000? I don't think the law was either meant to keep this in particular mind, but yes, potentially with one broom, you're trying to clean the entire room and potentially even throw the baby along with the water outside the window. So I think we'll have to have more holistic approach. Well, these rules have come in. It's important to get appropriate checks and balances. It's also important for us to understand how can they be implemented and what's going to be the ultimate consequences in case some sections of the OTT players decide not to comply with the same. Would we have the political will to go after those legal entities that are not located in India, or are we just going to be content with having mere paper tiger provisions of these rules? So a lot of things are going to depend upon political will. There's a lot of ambiguity, a lot of gray zones. I believe that require more clarity as we go forward, because that clarity will ultimately help and benefit all stakeholders so that they can all contribute into a more secure and robust cyberspace.
Yeah, absolutely. In fact, I was also going to raise that point. Prashant, do you agree that there is a lot more clarity needed in terms of these guidelines and how they will have to be implemented to begin with? Who are these significant intermediaries and how do you define them?
There definitely is a lot of clarity. The way we have introduced new terms, starting with the social media intermediaries to significant social media intermediaries, how do you really define who these intermediaries are? I mean, government has to now come out with a notification classifying a few intermediaries as social media intermediaries, maybe based on the number of users they have or various other parameters. So yes, so there could be more confusion there. Apart from that, even in the provisions that we have, Mr. Duggal mentioned about the OTT platforms. The question here is, do we need the same kind of regulation for an OTT platform? Again, whether there is a level playing field was the question raised by the minister. Now, this is quite different from broadcast media. As far as OTT is concerned, you identify whether you need to, let's say there are different platforms, you identify which platform to go and access your content. You pay for the content and let's say access specific content. It's quite different from a broadcast media where it's broadcast to everyone across the world, at least across the country. As far as OTT is concerned, and I also disagree with Mr. Duggal, as these cannot be considered to be intermediaries. These are platforms which are creating content, which make content available, and quite different from intermediate like, let's say, Facebook or even a YouTube for that matter. I mean, except for content created or YouTube, there could be some difference, but at least Facebook and Twitter for that matter. So there are, I mean, over a period when these guidelines are implemented, these rules are implemented, there definitely will be need for more clarity, more, as to how these rules will be implemented, how the classifications will work out. Definitely, we need to have more discussions, more clarity from the government as such. And also, I need to make one clarification, which I mentioned earlier about the originator aspect. The question was not with respect to the long-arm jurisdiction of the IT Act, but with a specific provision in the new rules, which says that if the originator based outside India, then as far as the rules are concerned, for the purpose of these rules, the originator who sends the message out from India, so for example, if somebody sends a message from the US, I forward it, I will be considered as the originator as per the rules. That was only clarified. My question was not about the long-arm powers of the IT. That definitely is there. But the rules clarify that if there is an originator in India, he has to be concerned, not the first person from outside India who sent the message. So if you have to really find that out, you need to go through the entire chain of messages. So the metadata will have
So
to
what happens? What happens? I'm just trying to understand. If the intermediary doesn't comply with it, do they have to shut shop and leave? Is that the only option? Legally, what are the powers that the government may have if a WhatsApp or a Signal says sorry, no can do?
legally they'll be liable for the content. What content could be there? Because as far as intermediaries are concerned, they get a safe harbor protection under Section 79 of the Act. And the moment they don't comply with these guidelines, these regulations, they will lose that protection, and they could be held liable for that content.
Okay, so they could
And
be
also,
yes. They could be held liable for that content. Very quickly, if I can just come back to that conversation on OTT again, Mr. Sidharth Luthra, I'm just trying to understand. You can talk about certification, that makes sense, yes. Parental control, all right, that makes sense. Although in the world of internet, I don't know how much can you actually manage to do that if you've already given access to the internet to your child. But the other aspect about 3-level grievance redressal system, bringing in even a interdepartmental government committee to look into it. Can that get problematic? People can watch content and get upset about content. Can they raise issues and write to the grievance officer to say, I thought this show hurt my sentiments?
Problem, and we must understand the distinction with OTT. Pavan touched upon it. There are two concepts, push and pull. What you're doing on television today is pushing your content to others and people can view it. In an OTT, each person registers. You have to declare yourself to be an adult. You have to have a mobile number. And then you can seek out certain specific content which you can see. So it's something which you're doing by consent. Now, when you're doing something by consent, and this is where parental regulation will have a relevance in OTT, but not necessarily in other areas of media. So therefore, my point is, it's a private space. OTT is a private space of communication between the user and the service provider for cost. And that, it's very odd. And we're having cases all the time where users come, they see content and they say, listen, now I've got offended, or now I find it obnoxious, and therefore I want to prosecute. This is becoming a serious issue.
Yes.
You view and you object. Second thing which I must tell you, which is very important also to be considered is, and just as an aside, I must add, the speakers before me were talking about that there is ambiguity in law, there is arbitrariness, there needs to be clarification. Well, I want everybody to know these are the rules. There is no scope for clarification. The government has taken a view, either the court looks at it, and the biggest concern for me is, though I disagree with my friend NAPPINAI and I'm concerned about what she said, this is really an attempt to override the Shreya single judgment and dilute the protection to intermediaries. That's something which is being sought to be done. My friend wanted a review, and that's my worry. The court struck down 66A because they said there should be a protection to people who are carriers of information. And OTTs are also more often than not carriers of information. There is a distinction between content they generate and what they carry for others. If they're carrying some for others, I don't see why they should not have the protection under Section 79. And 79 protection to intermediaries is becoming an eyewash by these kind of laws and regulations.
Would you want to respond to that?
Sorry?
Yes, would you want to respond to what Mr. Luthra just said?
Absolutely. In fact, a couple of points. One is, I think there is a misunderstanding in terms of what I said. When I said there has to be a review, I said it has to be a review with respect to 69A, not with respect to 66A.
Yeah.
So while Shreya Singhal was predominantly focused on 66A, it also went on to uphold 79, 69A, etc. And therefore, I have talked about 69A. On the aspect of regulating media, so we are all talking about it as if only India wants to regulate media. So I just wanted to highlight this aspect, especially with respect to age gating, where European Union has come out with its audiovisual media services directive, and pursuant to that, several of the European Union states, including Germany, Slovakia, and Finland, have come up with their own local laws for regulating content to ensure that certain kinds of content will not be accessible for children. Similarly, UK has also introduced this provision in its Communication Act of 2003. So even for games, there is a rating and a child block mechanism that is being mandated. So when India is talking about doing age gating or classifications, it is not doing something different. As I said earlier, the problem is the way in which it has attempted to do it. You can't force fit regulations into something where the Parent Act does not allow it and expect it to be implemented.
Okay, no, in fact, when I mentioned that also, Ms. NAPPINAI, I actually meant it as a good thing. And I've always believed that instead of censorship, which is what even, for our films, the certification board does, it should have been that system. That system should even be there even for our movies when you have to go out and watch, let alone for any kind of OTT platform. Labeling and, giving it that kind of a certification is the right way to go, so then people can then choose and even know what kind of access they want to give to their children, age-wise. But to say that this content,
artificial intelligence,
yes,
OTT platforms are driven by artificial intelligence. So a content that's being viewed by an adult is then being suggested to the child, because the OTT platform can't distinguish the age of the viewer. It is only doing it on the basis of which is the sign-in that you're using right now.
Correct.
Therefore, some kind of age gating is not something that is wrong, but it's just that it's not the right methodology.
Okay, fair enough. Point well taken. In fact, this is a good point to bring in Ritesh Bhatia as well. Ritesh, we had a conversation earlier in the day about how this can help empower people and the users. A lot of our conversation today was really about the government and the intermediaries. But I do want to bring in the aspect of the users and how they can now seek some accountability from the intermediaries for themselves.
So Tanvi, thank you for having me on your show. It's always a pleasure. So yeah, I think this is like a big relief for a lot many victims. As a cybercrime investigator, I'm always in the dark side. I don't mean to say the dark net. I'm saying I'm always in the dark part of the internet, wherein I'm just like getting complaints and so there are victims of sextortion, revenge porn, online grooming, and whatnot. You name it and it's there, and it's just getting murkier and murkier. And I was just training the cops of cyber crime branch yesterday, and they said like they really don't get any sort of support from these intermediaries. So I think this is a step in the right direction, where they have to now give a 24/7 support to the law enforcement officers. But my concern is there is also a particular point where it talks about defamation. Now anything that I would see on the internet, I mean, it could be defamatory for me or for somebody else. So, the cops will also be like loaded with many such complaints that this is defamation, and then it shouldn't happen. Then, we are working for certain, like, let's say, celebs or VIPs only, and these actual victims, like, again, they don't get justice.
Or political parties who may overload the intermediaries with their complaints.
Absolutely. So what happens, because if you understand the internet, it keeps the search engines and all the other websites also keep crawling for content. Now whether that's adult content or any kind of content, they keep crawling. Now the longer the particular victim's photographs stay on the internet, the higher the chances are that it is going to be distributed at so many places. It's going to be replicated at so many places, and hence it's very important that the cops register the FIR immediately, and these intermediaries, which have been kind of always been quite arrogant, I can say, towards the cops and towards the other agencies, now say, okay, look, we are just bringing this content down. And they should not only bring the content down, this particular guideline also says that they need to give all the other details. So they must say from where all it also originated, so that the perpetrator is caught. That's very important.
So that's actually the good side of having that policy in place. If the social media intermediaries will have to track down the originator for sexually explicit content, for rape threats, for any kind of pornographic material, pedophilic material that's actually being put out there and has to be pulled down immediately, and there has to be followed up with police action. I am completely out of time. My apologies to Ritesh. We ran short of time at the end, but thank you so much to all of our panelists, Mr. Luthra, Ms. NAPPINAI, and Mr. Sugatan. Thank you so much for joining us on this conversation. Viewers, there you've heard it. It definitely looks like what the government has come out with and announced is a mixed bag. There are the good things. The intent is good in terms of empowering the users, giving them a clearer, a more time-bound platform to get their grievances addressed, and a lot can be done about the ugly content which is out there, which must be pulled down, and making these social media giants accountable for that. But there is also the tricky side. The tricky side is about lack of consultation that may have happened with some of these intermediaries. The lack of clarity on what kind of intermediary are you, should you even be categorized on it, and how does it all really fit in with the existing legal setup, legal framework under the Information Technology Act. There you go. Completely out of time. Thank you so much for joining us.